practicable, right? And you would only need that knowledge because you must have a good reason to restrict my right that makes sense in a free and democratic society, right? So if the restriction does not make sense in a free and democratic society, it is an arbitrary restriction, and that would be against the principles of your human rights, right? All right, we have that they are non-discriminatory. What does this mean? This was the one that applied to everybody, right? So when you were saying that for this, it was really this, right? So non-discriminatory meaning that they apply to everyone regardless of your characteristics, yes? Ready? All right, so we have that they are indivisible. What do we think that means? Right, they cannot be separated. They rely on each other, and if one is breached, the other can be breached, right? So our rights are indivisible. And when we do our little scenario activity, you will see that there are multiple rights usually engaged when a right is breached, right? We have that they are participatory. What does that mean? Not just include. You should be involved, right? So you have, for example, the ability to vote, because when you elect your officials, that affects how your rights can be protected, right? You also, for example, you will see the parliament, when they ask for submissions, they don't send a personal message to an organization like JFJ or to the lay magistrates or to the DPP. They put out a notice in the newspaper or on the internet or both and on the radio, and they say if you are interested in making a submission, you send it to this email or you call this number or you put the information here, because you have a right to participate in the processes that will affect your rights. So any ordinary citizen can go to the parliament when they're reviewing legislation and make a submission, right? Because you should participate. They also say that they are inclusionary. This is attached to your participation. And what do you think that means? You're not left out, right? So when in the participation, you would have said what you wanted to see. To be included now would mean that some of the things that you say are seriously considered and are put in. Maybe not all of them, because you are not the only person that need to be included, right? It wouldn't be the whole population that need to be included. But the point of the inclusion is that it is considered seriously. You're not just participating as a show, right? Now, besides that, as we said before, your rights have obligations, right? So with your rights, you have the obligation to respect the rights of others. The state has the obligation to fulfill and protect your rights, right? Oh. Okay, so in Jamaica, we have a human rights framework. We call it a human rights framework. As we said, the rights, as in the list of rights that you have, they're in your constitution at chapter 3 in the Charter of Fundamental Rights and Freedoms, right? Yes? In addition to that, those rights are supported. All right, so 1 second. I understand that you're murmuring and stuff, but I'm training my voice because I'm hearing you at the same time. So if we can just be as quiet as we can, I'd appreciate that. All right, so with the rights that are in the Constitution, they're also supported by laws, right? So you have, for example, your right to life, liberty, and security of the person. You have your Offenses Against the Person Act that protects your right to life and your right to security, because security of the person means that you feel safe and protected, that you are not arbitrarily harmed, right? And your right to life obviously means nobody attempts to take that life or actually takes that life. And you know that you have offenses against murder, against unlawful wounding, against manslaughter, against grievous bodily harm. You have offenses against sexual assaults and other kinds of assaults, right? that protects your right to life, liberty, and security of the person. You have a right to freedom of thought, conscience, belief, and observance of political doctrine, a right to freedom of expression. Do you have a law that you can think of? If I say somebody breached my right to freedom of expression, what would I do? Sue them, right? Exactly. Because some of the rights don't have a law mechanism attached, right? So, whereas if somebody breach my right to security of the person, I can report them to the police. If they breach my right to freedom of expression, I'll have to sue them. That does kind of make it a little bit less accessible when there are no laws to protect the right. But that don't mean that it can't be protected, right? It's just a little bit harder to protect. Even though it's a little bit harder to protect, it's important to still protect it. And for example, with your right to freedom of expression, are you familiar with a case? I think I may have mentioned it in the last time I presented too. But with Kensington Primary, that's a school in Kingston, and they have a student with locked hair, and she wanted to go to school and was admitted to the school, and the school told her that she needed to cut the hair to go to school. Her parents sued them, right? Because they say several things, right? The freedom of expression was breached, freedom of religion, other things, right? When they went to court, this would have started in 2018, right? And they went to court the first time, and the court did not agree that the right to freedom of expression was breached. Because at that time, the court thought nobody had ever brought a case for freedom of expression. And at that time, the court thought freedom of expression means speech. Even though the way how our constitution is written, to persons who are in academia, it's obvious that it means more than speech. But if you're not in academia, then you have to test it. That's what the court is for, right? So while they went through that first case, they waited on the verdict, and the verdict come down in late 2020, and the judge said, we don't agree, no breach. So they had to appeal because they know that it's a breach, right? And they appeal, and then they had to wait on the Court of Appeal, and then they came down in 2023 and said, yes, there was a breach. Freedom of expression is more than speech. It includes all the things that go to your identity, right, and your culture. So it can't be just speech, right? And they won the case at that point. At that point, the young lady is in high school. She's no longer interested in going to Kensington Primary. But then that also means that any other student who would have a similar issue would not have such a hard time in that process, right? And we actually saw the Ministry of Education change their grooming policy and make a public statement about it and all of those things. And part of that was as a result of the findings in that case, right? So it's still important, even though it's harder, to action the rights in this way, to still action them, right? And it's a similar thing that those persons that I mentioned earlier in the Gibraltar and the Watton communities are doing with their right to a healthy and productive environment. So you have a right to a healthy and productive environment that has to do with the air that you breathe and the water that you drink, and, you know, having ecological things around you. So when people burn garbage in your community illegally, that is a breach of your right to a healthy and productive environment, right? So, well, so you should be able to report them to NEPA, because NEPA should be responding to any issues that have to do with, yes, exactly. So that is what you should be doing. And they will be fined, right? And it's not, if you don't pay a fine, then you know that you are imprisoned because that's a breach of the court. So, Miss, please finish your pretest. I can see that it's not. Mm. Oh, okay. All right. We'll address it at lunchtime. Okay. All right. So another right that I would like to highlight is your right to seek, receive, distribute, disseminate information, opinions, and ideas through any media. In your folders, you have a access to information pamphlet. The Access to Information Act, we've had it since 2002, and it is there to allow you to get any non-confidential information from the government or any company that has up to 50% shares from the government, right? So the state has given up to 50%, has 50% stake in that company. We can get that information if it is any government agency, department, or ministry. You can get that information. And one example of how we have used the access to information, even in our advocacy work, we used it on the access to information itself, and we used it on the child diversion. So for example, when we did our child diversion research, we would have needed to get data from 2020 to 2024. And so we would have made the request to the Ministry of Justice, to the JCF, to the Court Administration Division, all of the actors, the state actors that are involved in the child diversion process. And we asked them, how many children did you divert? What did you divert them for? Did they finish the diversion program? How long was the program? What kind of things were on their programs? All of this would not be confidential because they can make that information anonymous, right? Which is what they did. But having requested that information, what we ended up doing was helping to improve the system of data collection that all of these agencies do, except for the CAD, because they do excellent, great data collection there. But for example, the Ministry of Justice, it would have taken them time to gather that data because that would not be data that they're ordinarily consolidating. But now, having requested it, they ordinarily consolidate that data, right? So it will be more helpful for persons going forward who would want that information. But your Access to Information Act, it is there to facilitate that. And the pamphlet that you have will give you instructions as to how you can make an access to information request for yourself. We also have a website that assists you with doing that, so you can make it through there, right? You have a right to equality before the law. When we talk about the right to equality before the law, we talk about it in two ways. The law being applied equally and the law being written equally, right? When we talk about application, that has to do with our cultural biases, right? So for example, we have an offense called sex with a person under the age of 16, where we have two persons who are under the age of 16, and they'll say, oh, you know, it's boyfriend and girlfriend, whatever, but they're both under the age of 16. The legislation is gender neutral. It says a person who has sex with a person under the age of 16 commits an offense. That means both of those persons would have committed an offense. However, we have our cultural biases. So only one person is arrested. Who is arrested? The boy, right? So the boy child is arrested, and if he's diverted, he gets all of these diversion interventions, and the girl child is left to her own devices, right? Now that is an unequal application of a law that is in itself equal, right? The law applies to both. So that is just our application, but we have laws that do not apply to both. I will assume, I hope correctly, that a few of the ladies in here are married. No? A few? Okay. Well, if you are married, your husband can only rape you if there are specific circumstances present. If you have separated within the meaning of the Matrimonial Causes Act, if you are in the process of getting a divorce, if there is an order against him from the court to stay away from you, like a protection order, or if he has an STI and he did not inform you. So if you are in your marriage and none of those circumstances exist, and your husband forces sexual intercourse, there is no cause of action for you. Unlike a single woman. Right? So a single woman would receive all of the protections that our Sexual Offences Act allows. But if you are married, as long as the perpetrator is your husband, and none of those circumstances that I said before exist, you were not raped, according to the law. If you are a man, can you be raped? Yes. Okay. I know that And I'm glad that we all said that because I guess that would be what a cultural shift to say yes, men can be raped. In your legislation, though, that shift did not happen. So, in your Sexual Offences Act, we define what is sexual intercourse, and we say sexual intercourse is the penetration of a vagina by a penis, right? And then we go to Section 3 and we define rape. And in Section 3, we say rape is. Wait, actually, I'm giving you the exact wording. You hearing me? A man commits rape if he has sexual intercourse with a woman without her consent or recklessly not caring as to whether or not she consented. So, she didn't consent, or you never care whether or not she consent, that would be rape, right? So that means only a man commits rape. Only a woman can be a victim of rape. There are no male victims of rape in Jamaica under the law, right? Because rape is forced sexual intercourse, and you can only have sexual intercourse by penetrating a vagina with a penis. So, and worse, the legislation specifically says a man commits rape. It doesn't say a person. Remember earlier we spoke about sex with a person under the age of 16, and I said it says a person who has sex with a person under the age of 16 commits an offense. When we talk about rape, we say a man commits rape when he has sexual intercourse with a woman without her consent. So that means if a woman was to inebriate a gentleman, ju- so she drugs him or he's under the influence of alcohol, otherwise not in control of his faculties. Keeping in mind that to achieve an erection, that is an automatic response. And you can achieve an erection even if you are unconscious, right? Okay? She achieves an erection and has sex with this man. That may be an offense, yes, but it would not be rape. The most it could be is indecent assault. Indecent assault carry a maximum sentence of 3 years, right? So it would not be on par with a rape offense. If a man is forced into sexual intercourse by another man, what is that? Under the law. Buggery. In our legislation, and this can be your homework, you can go back and look at the offenses against the person act. Section 76, 77, and 79. If you read them, you will realize that they do not contain any words that discuss consent, because buggery is a status offense. Status offense means it happens as it happens. So, if you have anal sex, you have committed buggery. Whether you are male or female, right? You have committed buggery if you have anal sex. Consent is immaterial. So, say for example, you are a woman and you and your husband, boyfriend have had anal sex, and and the police see you have anal sex, because that would really be the most likely circumstance for which you would be arrested, other than a report being made, right? They see you having anal sex, they are to arrest you both, right? And the police you would not be able to say, he forced me into the anal sex, because that is immaterial. Just the fact that you are having anal sex is illegal. Whether you consented to it or not is immaterial, right? Which means that, technically speaking, if you are an adult man and someone has forcibly buggered you, the police should arrest you when you come to report it, right? That's not what they do, but also you will realize that no one actually reports that. Most of the cases that you would have seen in maybe the last 5 to 10 years would have been cases involving children or cases involving women, but no cases that involve men, because, like I said, our cultural biases, but also our legislative biases now, might affect the kind of service that they receive when they make that report. Like I said, we don't know of any cases where they would have charged them both in a situation where there was discussion about consent. But we also don't know of any cases where there were two adult men and there was a discussion about consent, right? So that is the challenge. So when we look at the equality before the law, we have some provisions that are equal but are not being applied equally, and we have some provisions that are unequal and would need reform, right? All right. So we also have the right to equitable and humane treatment by any public authority in the exercise of any function. And equitable and humane treatment has to do with being treated well and being treated similarly. So in your role as a lay magistrate, you would be a public authority. And when persons come to you, they would expect that as a lay person, as a citizen, they would be treated the same as any other person that would come to you. And that treatment would not be bad treatment. So you can't say, I treat them all the same, I treat them all badly. You would need to also treat them humanely, right? You have the right to freedom from discrimination. In our constitution, our right to freedom from discrimination has a limitation and it does not have a basket clause, right? So it is a closed list, male and female, race, place of origin, social class, color, religion, political opinions. Importantly missing from that would be persons living with HIV, for example, health status, or persons living with disabilities, right? Those are not listed as a part of the protected characteristics. There are other pieces of legislation that protect your rights to freedom from discrimination, for example, on the basis of disability, because we have a Disabilities Act, or on the basis of a person living with HIV, we have a national HIV policy that speaks to that. But it is not in the Constitution, right? All right, we have a right to privacy, and when we speak to the right to privacy, that is protection from search, privacy of the home, communications, family life, right? So when you are, well, we're going to discuss search and all of that. But yes, so you have that right. We have a couple of laws that protect that. So in terms of the search of the person and the property, we know that anything that governs our Jamaica Constabulary Force would deal with that. So your Constabulary Force Act deals with that. Your Criminal Justice Administration Act can deal with it, and several other pieces of legislation. When it comes to respect for the protection of private and family life, you have common law in which you can sue somebody, for example, for breach of confidence or for a breach of your privacy, essentially. You also have the protection of your property and other communications, particularly in terms of communications, identity, and personally identifying information. You have your Data Protection Act, as well as your Cybercrimes Act that would speak to, at least cybercrime speak to your electronic communications. Data Protection Act speaks to the protection of your personal and sensitive personal data. So that would include these things that have to do with your family life, but also identifying information, your name, your address, your date of birth, and that kind of thing, right? So Data Protection Act deals with those things. We have, I'm not going to go through all of the rights individually, but you have the list in your folder. There's a handout that speaks to Introduction to Human Rights, and they're on it. So you have the right to protection from torture, inhumane or degrading treatment or punishment. I think that one is self-explanatory, right? You don't expect to be treated, to be beaten, to be tortured while you are in custody of the state, right? You have the right to freedom of the person, so you should not be deprived of your liberty unless it is in accordance with the law. So even I can breach this right to freedom of the person. So if I exit this room and I lock these doors and you cannot leave and you want to leave, I have breached your right to freedom of the person, right? And you can sue me, actually, for false imprisonment. Can sue anybody for false imprisonment. But yes. Mm-hmm. What do you mean? Would that be a false imprisonment, or would that be a punishment? Right? Because if it wouldn't be, I remember, say you have to justify things based on arbitrariness, right? So is it an arbitrary action? Is it that they are making you, if they were making you sit down and write lines for no good reason, then yes, that would be a breach. But if you did something and they explain to you why they have given you this punishment and now they're asking you to comply with the punishment, then that would not be a breach. So again, if you're gonna the test always when somebody's rights are going to be limited is if it is justifiable in a free and democratic society, right? A free and democratic society. So of course, a free and democratic society would expect some structure and punishment to be a part of that structure, right? So that would not be an arbitrary reason to restrict the right to freedom of the person because I wanted to understand the harm that you have done, which is the same thing we do if somebody commit an actual crime, right? We restrict their right to freedom of the person that we can get an idea of, so they can get an idea of the harm that they have caused, right? We also have the right to due process. In particular, this has to do with when you come in conflict with law, right? So we did say you have to be told why you have been arrested or detained. You have to be considered for bail. You have to be able to speak to your attorney. An attorney should be able to assist you throughout your case. So if even from when you are just detained, you should be able to get duty counsel. When it is that you're before the court, you should be able to get legal aid. You should be able to speak to your family while you are in custody. You should be receiving medical care while you're in custody. And you should also be heard by an independent and impartial court within a reasonable time. And we've seen two recent cases where those things did not happen, right? So, for example, we saw Mr. Palmer's case, Vibes Cartel's case, where his case was not heard by an impartial court because there was a tampering with the jury and there was no response to that tampering. And so his attorneys rightfully appealed the conviction and and he was acquitted, right? Because, well, they ordered a retrial, but it never makes sense to retry, right? It would have been too expensive and it would have been a waste of the country's resources to do so. Either way, he would not have had a fair trial. So justice would not have been served for either person, right? Similarly, we would have seen another recent case that our former board chair had conduct of, where the I can't remember his name. Oh my gosh. Anyway, the applicant, he would have been convicted for an offense and he filed an appeal. And his appeal would have required them to give him dates, give him the statements from his case so that he can prepare his arguments and all of those things. All of the things that should happen after an appeal is filed did not happen. And he wrote to the Chief Justice for years and years until finally he was able to get Mr. Clark to assist him. And eventually he was able to have the appeal heard. When his appeal was heard, he had already served more than the sentence he was given. Because when you are going to get an appeal, your sentence is suspended if you were convicted, right? So it's suspended and you remain in lockup, right, until your appeal is heard, right? So you can imagine that he will be seeking compensation from the state for all of those years that he should not have been locked up, because worse, his original sentence was excessive, and that was the basis of the appeal, that the sentence was too excessive. And having that be the basis of the appeal, and then you spend more than the sentence in detention, you can imagine also the pain and suffering and distress damages that will come with that, right? All right. The last one I'll highlight is in terms of your protection of your property rights. Where that is concerned, you are free to do so, but you cannot do so. But you still have a duty of care. This is what I'll say. You still have a duty of care, right? So if you are, for example, aware that there is a frequent trespasser on your left side fence, and you place something there that is concealed, that will harm that person should they come over the fence, and they come over the fence and they are harmed, that person can sue you. And when that person sues you, they will have a good, strong cause of action, because you have a duty of care even to a trespasser. So if I have no way to foresee the harm and then I am harmed, then you would have breached your duty of care. Yes. Is it? Can be. But your trap is actually detrimental, not can be. I get you. Mhm. Okay, so all of this go back to you. You see, you're inputting something on me. Come in, you say, I am coming to harm you. How would you know that? I see your hand. How would you know that I am coming to harm you? That's different. But also, I still wouldn't be able to set a trap for you. Right? That's different. If it is that it is unlikely that you're gonna know the motivation for why the person is unless they actually said it. Right? They're just a trespasser. Even if the person had said they were going to harm you, you would not be able to set a trap for the person. That is what the police is for. You would report them to the police for the police to arrest them or for the police to warn them or whatever intervention they would do. But when you take it upon yourself now to set a trap for them and they are harmed by the trap, you are responsible for the injury that was caused. That is the common law, so it now go revisit, because it's not in any legislation. That is your common law principles. You have a duty of care, even to a trespasser. I saw your hand, but I'm going to say something else on it after he contributes. No, it's that the only way it would change is if we were to legislate out of it. You have to legislate out of common law. But when you have common law in place and no legislation that counteract it, common law is what we go with. Right? So. Mm. Mm-hmm. Yes. 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 Exactly. Yeah, it's not unfortunate. You know, the point is that there is no way that your property is worth more than life, right? And so you can go as far as you can, except for harm the life of another person, right? All right, so when we talk about human rights violations, as we said earlier, an individual can violate your rights, right? But most times when your rights are violated, it's by an action or inaction of the state. So, for example, you are a woman experiencing domestic violence. Your partner, who is using violence against you, is breaching your rights. They're breaching your right to security of the person and your right to life, right? You go and report it to the police, and the police respond. That would have fixed, that would be the redress for that breach. You go and report it to the police, and they don't respond. The police have also now breached their right because they would have failed to protect that right, right? Now, in that case, that is an actionable human rights violation against the state because the state has a responsibility to respect, fulfill, protect the rights that you have, right? It can also be a failure of the state if there is nothing to protect the right, right? So say, for example, say you have a right to freedom of religion, right? And if your institution says that you can no longer practice your religion, and the state, and you go to sue, and the state say you can't sue, then that would mean that there is no mechanism to protect your right to freedom of religion. So the state would have also breached their right there in failure to protecting it. Taking positive steps to realize that, oh, that was the first one with the police, right? So the final one, failure to respect, is where the state itself is the person breaching your rights, right? So for example, you go to the health center to receive service and you are discriminated against, right? That would be a failure to respect your right to freedom from discrimination. So human rights violations can happen on the two fronts, on the individual front, on the state front. And of course, when we say on the individual front, we also mean persons who are, well, companies, because in Jamaica, our companies are persons, right? Now, to enforce your rights, the ones that are not in your legislation, so there's no law that support them, you would go to section 19 of your constitution, and that gives you the ability to apply to the court for the court to make a ruling on whether or not your rights was breached, and then to provide whatever remedy the court sees fit for that breach of your rights. You can apply for this even if the breach was not directly to you, but it would affect you. So, for example, we saw recently, no, let me use an old case. We saw in 2018 where, who was it? I think it was Philip Paulwell or one of those persons on the People's National Party, Julian Robinson. He would have brought the case against the national identification legislation. The legislation wasn't even fully in place as yet, but having looked at the legislation and seen that it would have affected the rights of all citizens, including himself, he made an application to the court. But any of us could have been the person named in that application because we would have all been affected by a piece of legislation like the NIDS, right? And we saw them do a similar thing last year with Dayton Campbell and the states of emergency legislation, where they challenged that in the court again. And we're going to talk a little bit more about that a bit later down. But either way, that is to show that the Section 19 mechanism is there even if your rights have not yet been violated, and even if it wasn't directly to you at that time, right? It's just that you can also be affected, right? The court can look into those matters regardless. Okay, so we have an activity. So it's unfortunate for your live streamers who will not be able to participate in the activity. But we will be doing something real quick. So you'll be looking at these scenarios and you are going to be telling me if what rights were engaged and whether or not the right was breached. We are going to work with the two sides as we have been doing. You will get either 2 or 3 scenarios on this side, and you will get either 2 or 3 scenarios on this side, and you will say what rights were engaged. That don't necessarily mean they were breached, they just came up in the scenario, and then what rights were breached. So 1 second, let me ensure these are the right scenarios for you. Okay. Okay, so I'm gonna ask a rep from the left side to photograph this scenario for me, because you're gonna get 3 of them. Okay, got it? All right, this is the next one. Okay, final one. All right, so for this side now, this one first. We got that one? Yes? Okay. All right. We will go to just when you're when we're well, it's fine. I'll know which one. Got it? Yes. You're gonna get three. Okay. This is the last one. All right. So I am going to give you back the sheets. You write on the opposite side. So you get one for each. You can write on the opposite side of this, one for each scenario. And you are to tell me, just a reminder of the instruction, identify the rights that were engaged, whether or not any of those rights were breached. You should still have markers on your table because I don't think I took them back. So they have their own. There's one here. Who doesn't have a marker? Okay. So I'm saying the question is that if it is that they want to ask the teachers to have assigned to address school, then they would say, why they use address school because of whatever this reason. And then that would be well, but I will talk completely up to their fashion decisions. Yes. When you decide, I'll split the room into two groups. Yeah, work on all three of them. So when I am finished, all three things must have been discussed, and you must have rights where you think were engaged, and whether or not they were breached. Three. the third one. This was the third one. So, hold on. There's somebody that did not send. Yeah, Mr. Robinson? Yeah, Mr. Robinson? You have to sign both of them. Okay, so scenario one. Okay, so that's why I tell you know which one fit take picture of and which one them fit take picture of. I gave you three different ones. I gave you three. Yes, it was 2, 4. Right. So it was 2, 4, and I think it was 5. 2, 4, and 5, 5. And you guys got case study 2, 3, and 5. Okay. So I'm giving you guys. One second. I'm giving you guys 15. I'm giving you guys 15 minutes to discuss and complete it. Right? So this side is doing 3 scenarios, scenario 2, 3, and 5. This side is doing 3 scenarios, case study 2, 3, and 5, right? All right. So you guys can split them or you guys can do them together. It's up to you. Which one you like? Oh, yes, you may. Miss, you're right too hard for my marker. No, I've no more marker. I don't have any more, so you'll have to try and work with it. 5 more minutes. 5 more minutes is good. 5 more minutes is good. So we're going to discuss in 2 more minutes. Okay, are we ready to discuss? Are we ready to discuss? Hello? Yes? You guys can't just ignore me, no? Only you want to answer? Okay, we are ready to discuss now. So please let us. Okay, so we'll start with scenario 2. A 15-year-old girl who attends a secondary school in a rural parish has been absent from classes for several weeks. When she returns, the guidance counselor notices that she's visibly pregnant. In a private meeting, the student discloses that she's pregnant by her mother's 42-year-old common law partner who lives in the family home. She also discloses that the abuse has been ongoing for over a year and that her mother is aware but has said nothing because the partner pays the rent. The guidance counselor does not make a report. The following week, the principal tells the girl that she cannot return to school in her current state and must transfer to an alternative program at another institution. Okay? Yes. So what did we decide?
The right has
So you're going to tell me first the rights that were engaged, so they just came up, and then you're going to tell me if they were breached.
Um, the first one we look at is the right to every child to be protected as a minor. That she was 15 years old. The next we look at is the right to equality before the law. And the next was the right to security as a person.
and expounding on them. I'm going to try my best. All right. As it relates to equity or equality, is that the guidance counselor or the principal guidance counselor should have made a report to the relevant authority. So we're talking about child development, the CDA, and they would make the requisite guidelines as to what to do. In terms of the principal, telling her that she needs to go to another school. Are you hearing me clearly now? Oh, there's an echo. There's an echo. There's a delayed. Let me go. The school should have ensured that the incident was reported using the proper channel and seeking guidance from the channel. Also, as it relates to recommending the student to go to another school, guidance also should be sought where that is concerned in terms of transfer and the best place the child to be placed. The mother also, in terms of a secure environment, that was not, despite the fact that the person was paying rent and supporting the family, the mother ideally should have, but we know in the Jamaican situation where that is taking place, many women are afraid of doing that because of the financial support that they are and have been getting from their partner. In terms of freedom of the person, we want to believe that based on what was happening within the household, the young girl was afraid to report. And although we probably want to read into the scenario that the mother would have known about it, but we know that some mothers do conceal what's happening because of the financial support and other supports that she would have gotten from the man. Two, I'm looking at two that were breached, the right equity as it relates to the law, with the school making a decision without consultation, the relevant authority. Right. By public authority. For every child to be protected as a minor. Those are the two. Right.
Is there any right that you would have added to what they said? So they said the right to every child to be protected as a minor was breached, and the right to, say it again for me, equitable and humane treatment by a public authority in the exercise of any function. Is there any other you would add to this? What about freedom from discrimination? On the basis of being female, Because if you were male, would you have this same situation? If you impregnated your teenage girlfriend as a boy at school, would they remove you from school? No, but your teenage girlfriend would be removed from school, right? So that would be a matter of discrimination because you are treating her differently on the basis that she's female, right? Any other one you think? I like that you included security of the person. That is the right use of security of the person in terms of feeling safe, and that would have been breached several parts, right? The guidance counselor not assisting, the stepfather, the mother, everyone would have breached it there. All right, any other comment on this scenario before we move on? No? All right, any comments from the online people? All right. So we go to case study 2. A remand prisoner at a rural correctional center reports to a visiting JP that inmates were confined to their cells for 20 plus hours per day. They have no access to running water for bathing. They sleep 3 to a cot, and that one inmate with a serious wound received no medical attention for 2 weeks, causing the wound to become severely infected. Several inmates corroborate the account. Who had that one? So,
We did. So we have the right to equitable and humane treatment and the right to medical attention.
Basically, the right to enjoy a healthy and productive environment.
all right, thank you. You would have realized in your constitution that you don't actually have a right to medical care, right? But I see that you have due process here. So it would be a part of your right to due process, right? Because you have been detained. So it would be a part of that right. But also, you have a right to security of the person, right? And even though you are a prisoner, that right is not restricted, right? So the responsibility has just shifted to who is responsible for your security, right? Equitable and humane treatment was correct. So equitable and humane treatment by a public authority in the exercise of any function. You could have also added freedom from torture, degrading, punishment, or treatment, right? Because not being able to move, not being able to bathe, not being able to sleep, those are considered torture situations, right? So you could have added freedom from torture. All right, so next scenario. Someone got this one, right? Yes? Okay, a 21-year-old man. You guys got this one? Nobody got this one? Yeah, 4. Okay. All right, so James is a man known in the community to have a mental illness. One afternoon, he begins to have an episode on a busy main road, attacking persons nearby and injuring several of them before officers arrive. A shopkeeper has called the police, who responded alongside medical personnel. On arrival, the officers assess the situation and move to subdue James. He resists strongly and is injured during the restraint. He's subsequently taken for medical and psychiatric treatment. His family later complains, saying the officers were too rough and that James could not help his condition. Who had this one? All right. Who is going to talk on it? Who is getting the mic?
Thank you. All right, so we identified the right to life, liberty, and security of the person in terms of James was basically attacking others, so they have a right to security. We looked at the right to equitable and humane treatment by any public authority in the exercise of any function, and the right to protection from torture or inhumane or degrading punishment or other treatments. Those are the rights identified. In terms of breaches, well, we didn't all agree, but we think basically that none was breached. none of his rights were breached because the officers basically did what they had to do to restrain him and they took him for care.
You're exactly right. Those were the right rights to identify, and they were not breached, right? It is, that's why I added an element of force to it, but just the use of force does not mean that there's a breach, right? Because there's legitimate ways to use force. And in this situation, this would have been one of those ways. They tried to de-escalate before they used force, and they used the force based on what we have here only to restrain him, right? They didn't further beat him up or anything of that nature. So this would have been, without more, a correct use of force, right? And therefore, none of his rights would have been breached. He would have breached the rights, though, of other persons in the vicinity because he would have affected their right to life and security of the person because he would have been threatening and attacking them, right? All right, so we had case study 3. Okay. So a JP in a rural parish receives a complaint from a school principal. Did we just do this one? No. Okay, that a 13-year-old student has been absent for 3 months. Upon inquiry, it emerges that the child's guardian has sent him to work full-time on a private farm harvesting crops. The child works from 5 a.m. to 6 p.m., is not paid directly, and has not attended school. The guardian argues that the family needs the income to survive. Who's going to take the mic for this? Who's taking the mic for this?
Right to the protection as a minor. Minor. Right to an education.
That would go back to your right to protection as a minor, right? So any other? No? And you're saying that right was breached? The ones who are not identified? Right, so the right to protection as a minor, under your Child Care and Protection Act, you have provisions that state how a child is allowed to work. It's a limited period of time, it's specific kind of light work, it can't be no hard work, and it can't be for this amount of hours, because this would be a full-time job, right? And that would be against the law under your Child Care and Protection Act. So that would go to your right to protection as a minor, right? But then you have the fact that he's 13 and has not been attending school. He didn't say exactly for how long, but we can assume a decent period of time. Oh, it did say, my bad. It said 3 months. Yeah, it said he has not been attending school. And we didn't see that it was a high school, so we can say maybe to education at the pre-primary and primary level. That must. Not must. But yes. All right. Do we have anything else to add to this one? In terms of... Yes, they mentioned it. All right. So I think the last one you have is scenario 5 on this side. Scenario 6? 5. Over here have 5? So which one is your last one? No, you have case study 5. Oh. So this is the one that you have? This is the same one you have? Okay, so I guess I mixed up and gave you both the same one. So you can both respond. All right, so someone else read for me, please.
Police respond to a 2:50 a.m. call from neighbors reporting screaming at a house. A woman meets officers at the gate crying and holding a swollen wrist. Her partner is inside and appears intoxicated. While speaking, the woman repeatedly tells the officers she does not want him to be arrested because he pays the rent and she has 2 children asleep inside. The man begins shouting from inside the house that the police cannot enter because it is his property. Officers enter anyway and separate the couple. During the interaction, the man becomes agitated and moves towards the woman. An officer restrains him and places him in handcuffs. The woman then begs officers not to take him away and asks them just to warn him. One officer insists on carrying out the arrest. The children wake up crying during the arrest, and the man shouts threats towards the woman as he is being taken outside in view of neighbors gathering on the road.
Thank you. I'll start with you in terms of what rights you thought were engaged.
The first right we have is the right to life and security of the person. That involves the neighbors. They called the police and they responded. All right. And then right to protection from torture or inhumane or degrading treatment. So the police restrained the man, right? Yes, in order to protect her from the torture because there was evidence of hurt on her wrist. Yes. Right. Right. Right to due process. Yes, yes. This is part of it, you're right.
Are any of the rights breached?
No. The arresting.
So what rights were being engaged? And as we said, due process will be involved because it's been arrested.
Yes, for criminal offense.
So now you are going to tell me which rights were breached. So from the other side, which rights were breached? Because we get the same scenario.
Yes. Mm-hmm.
All right, raise your hand if you think the right was the right. Think it was breached. Why do you think it was breached?
Because the man had asked them not to enter his property, and because it's his private property, they entered.
Okay, so your rights end where they start to infringe on another person's rights. He committed an offense on you, and so the police would have all authority to enter the property to stop the altercation. He threatened her in their presence, they would have all authority to arrest her, regardless of what she wanted or not wanted, because they saw an offense being committed. So yes, these rights were engaged. Yes, these rights were engaged, but they were not necessarily breached because this would have been the appropriate response in a situation like this. Because alternatively, say he was to leave here now, these officers were to leave here and try to get a warrant and come back. She could have died in that time, right? So their response would be to protect everybody. The citizen that made the report, the gentleman from himself, the children from the argument, themselves as officers who were also being threatened by this gentleman, and the community at large, right? So they would have responded appropriately. There's one other scenario that we have not discussed yet. What is that? Case study 3? Case study, which one was it, guys? Assist me. Scenario 6? Is it 6? At this side, would I have it? At this side? No. Which three scenarios did you get? So case study 2, 3, and 5? So this one with the remand prisoner? This one with the complaint from the school principal? And then the last one you got was this? All right, fine. Okay. So I think we would have, I hope, engaged with what our human rights are, how they can be breached, that they can be engaged without being breached, right? What happens when they are violated, right? So what we're going to do now, we're going to take a 10-minute break because some people did not get to refresh themselves. So we refresh ourselves. 10 minutes, we will be back. It's 11:38, so we'll be back at 11:48. I'm sorry? we're ready to restart. All right, so we're gonna talk a little bit about interfacing with law enforcement. We're gonna talk first about search, and then we're gonna talk about our all in one. So about search. Okay, so about search, I'd like somebody to tell me under what circumstances a search of your person could take place by a police officer. Yeah. Okay, so you match the description of someone who what? Mm-hmm. 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 Yes, your person. Reasonable search, which is what he's describing, right? So when he said, for example, you match the description of a person that was involved in an offense, that would be reasonable suspicion because you don't know that it's me, right? But I match the description, right? Or say you observe a bulge, like I observe a bulge on this gentleman here. So you observe a bulge on my side. You can't see what the bulge is, so you have suspicion that my bulge is an illegal weapon or a weapon that I should not be carrying otherwise. So you have asked for a search, right? So reasonable suspicion is not just ordinary suspicion, right? You look away, someone wants to search you. It is more than that, right? All right. Similarly, as to the person with your vehicle, it is also to be searched under circumstances of reasonable suspicion. Of course, it can be searched if you have committed an offense under the Road Traffic Act and you have been stopped on the basis that you committed an offense under the Road Traffic Act, a specific kind of offense under the Road Traffic Act, then it can be searched in those circumstances. But it cannot be searched, for example, as a part of a national roadblock without more, right? Yes. No, so they would need to tell you. Remember, so earlier we say you have a right to privacy. And we also, hold on, and we also say that your rights, if they're going to be restricted, which are search of your vehicle, your person, or your home, would be a restriction on your right to privacy. Right? So we say if your rights are going to be restricted, it have to be for a non-arbitrary reason. So if they stop you and request a search, it must be with something else. So I'm requesting a search of this vehicle because this vehicle matched the description of a vehicle that was involved in a robbery. Or this vehicle, we have information that a vehicle matching this description was involved in offenses with the Firearms Act, with the Dangerous Drugs Act, with your parental larceny legislation. But it can't just be that I'm stopping you for a search. If you're just stopping me for a search, that means that I can refuse because I have a right to privacy. Right? Oh, okay, sorry. Go ahead. Okay, so what I have found to be helpful, but I don't advise everybody do what I do. What I have found to be helpful is to ask specific questions, right? So I say things like, okay, under which legislation do you have the authority to search this vehicle? But that's why I tell you this now. Right? But in those situations, I think if you don't know the information as I would know it, you comply. If you think there's something wrong, after you have complied, you report it. You can report it to, well, it depends on what kind of redress you want, right? But you can report it to different agencies. Any instance of police misconduct is an issue for iProbe, it's an issue for Indicom, it's an issue for JFJ. So if it was that you felt as though you were not in a position to refuse, but you knew that the search was illegal, you can still comply, but you report it afterwards. The thing is, that can be a double-edged sword, but only if you actually do something wrong, right? Or if you are ignorant that what you are doing is wrong. So, for example, if anything that is found in an illegal search is still evidence that can be placed in court. In other jurisdictions, if it is found in an illegal search, it is fruit of the poisonous tree, and it cannot be a part of your case. We don't have that here. So, the police actually have an incentive to conduct illegal searches. And when it is that no one challenges the large number of illegal searches that take place, then they will find that there is no issue, right? So it would have to be a matter of you, even if you do comply in that moment, not to let it go without making a report. And it is also something that they're fully aware of. The court has ruled on it multiple times, but there's a very famous case called the Heman's case that speak to the rules of search very specifically. And in that case, they were even dealing with the roadblocks, the stopping of a vehicle for a search with no additional reason included. And the court was very clear that that is illegal and that that kind of behavior is not within the realm of the power that the police have, right? So when we're dealing with search, person and vehicle, it is reasonable suspicion. And reasonable suspicion comes with information or observation, not just your feeling of me doing something wrong, right? When it comes to your home, you need to have a warrant. There are, yes? Well, all I would usually pose to them is, under which legislation are you requesting to search the vehicle? Because if you're requesting to search my vehicle on reasonable suspicion, even if they say reasonable suspicion, I would say reasonable suspicion of what? Because it cannot just be reasonable suspicion. It must be reasonable suspicion that I had just committed, I'm about to commit, or you are seeing me commit a crime, right? And that crime could be illegal possession. It could be predial larceny. It could be the transportation of dangerous drugs. But you would have to give me one of those reasons as to why you would be searching my vehicle, right? So you are searching my vehicle, one second. You're searching my vehicle because you have information that I'm carrying illegal cigarettes in the vehicle. That is a breach of your customs legislation, right? I saw her hand first, and then you, and then you. So yes. No, not you, ma'am. The lady behind you. Sorry. No, so there's no such thing as a spot check. There's no such thing as a spot check. And in fact, the spot check was what the case was about. The Heman's case, that was what it was about. There's no such thing as a spot check. So that is not a reason. So that is not, so in those situations, you can say to the officer that you are not complying with the search. See what they do after that, but on what basis? Keep in mind, officers are responsible as much as they are a part of the JCF. The JCF is bound by these rules. Officers are responsible for the actions that they take that are ultra vires to the rules that the JCF have. The commissioner himself, and we have met with him, me personally have met with him, has put out multiple public statements on this specific issue of the search. You can Google it. The current commissioner has put out statement on this specific issue of the search. that there is no spot check search. He's put it there, right? So that is not a reason. So if you are getting that reason, that is something for you to report, right? I saw your hand. 1 second. I saw his hand. Yes. No, but you couldn't be looking for it in my car unless you have information that my car have it in there. That would be the only way. So if you say we are stopping, say for example, you say we are stopping Toyota Axio because we are looking for we're stopping all black Toyota Axio that pass here because we are looking for a black Toyota Axio that contain dangerous drugs or weapons or this or that. So we're looking for that. And you are in a black Toyota Axio. That is a reason to stop you, right? Or them say them don't know the full make and model of the car, but they know that it is a black car that is containing the things, and you are in a black car and them stop you, then that would also be reasonable suspicion. But just stopping me to check if I am maybe doing something illegal is illegal. You have a right to privacy, and you also have a right to freedom from self-incrimination. That is why in that case where there is a high-profile family where a child has died and the court would like to access the lady's phone and she will not put in the password in the phone and there is nothing that they can do to make her put the password in the phone because she have a right to privacy and a right to freedom from self-incrimination. So if she knows that something on the phone for incriminate her and she don't want to open it, you can't make her open it. That is what your right to privacy say, right? So when it comes to these searches, there is to be reasonable suspicion. Person and vehicle, reasonable suspicion. When it comes to your home now, you know, say it is a warrant. And the exceptions for your home are much less, right? Yes. Police cannot search her phone. Your phones, oh no. They have no authority to search your phone unless the phone has been taken as a part of the investigation. So them can't stop you and say, open the phone, let me see what is in there. They can't do that. Yes. So if it is taken for but then also, you can search it. I don't have to help you to search it. So it is my phone. I have a password on the phone. You have taken it for your investigation. You are asking me to assist you with your investigation to put my password in the phone so you can access it. I say no, there's nothing more you can do. You cannot compel me to put in the password. You would have to find a way to get into the phone without me giving you the password. So if you want to call Apple and make Apple open the phone for you, if you want to call Google and make them open it, you want to do that because people have done that in other jurisdictions, right? Them call the manufacturer or them go to the service provider and them say, unlock this phone for me, and them unlock it. That you can do because you have the right to get the information. But I don't have the right to give up my right to privacy or my right to freedom from self-incrimination by giving you the password. They can take it, right? They can take it because that's a seizure, right? But they wouldn't be able to force me to unlock it. Which is why if you think say dangerous things on your phone, you can't put nothing on it like Face ID or like whatever. Because if they unlock it that way, it is unlocked. And now they can search it, right? Yes. I'm sorry. In Mhm. They could always have asked you. But they could always have asked you. But you don't have to give them. Right? They can always ask you, but you don't have to give them. You had your hand up, sorry. Mhm. To iProbe. That is the inspectorate. iProbe, IPROB. The Inspectorate Professional Oversight Standards Bureau or something of that nature. That is an internal mechanism for the JCF. Yes, you can go on Google and find it. You can call them and make the report. You can also report it to Indicom. You can also report it to JFJ. So wherever you want to report it to, you have those three agencies. Yes. They're supposed to tell you why. All right. You have, remember, say, everything that we discussed in this goes back to the fundamentals, right? Your right have to be restricted for a good reason. You have a right to freedom of movement. Your right to freedom of movement is to move around Jamaica, right? So if you are in your car, you are exercising your right to freedom of movement. You are moving around Jamaica. If the police stop you, you have been detained, right? They must explain now why they have restricted your right to freedom of movement around Jamaica and stop you here. When they stop you, they can say, they might check your license and registration to make sure say you're in compliance with the Road Traffic Act, which is a reason to stop you because you must be in compliance with the Road Traffic Act, right? They have stopped you because they have observed that you are not in compliance with something that is in the Road Traffic Act. That is also a reason to stop you. Or they have stopped you because of any of the other reasons that we said that are reasonable suspicion to do with offenses that are not in the Road Traffic Act. That is also a reason to stop you. But if they are just stopping you to stop you, then that was an arbitrary restriction of your right. Right? So when they stop you, what you want to hear is, ma'am, we have stopped you because, and I am officer this, because I'm supposed to introduce themselves. We have stopped you because we are looking for a black Toyota Mark X that is suspected to be involved in an offense, and you are driving a black Toyota Mark X, so we stop you. Or we have stopped you because it appears as though your fitness or your registration or your whatever is not in compliance, and they are going to do the check now. So you need to stop for while we are checked so that we can ensure that you're in compliance. Those are reasons that are not arbitrary because those are going towards your public order and safety, right? Wearing your seatbelt, because not wearing your seatbelt is an offense within the Road Traffic Act. So the Road Traffic Act has a lot of offenses, you know. So you want to be sure that you know what they are. So like your broken tail light, that is an offense. You're not wearing your seatbelt is an offense. You are driving with the phone in your hand, that is an offense. You are using the phone while you are driving, that is an offense. So they can stop you for all of those reasons and say you are in breach of the Road Traffic Act. Right? Yes. Exactly. Exactly. So just the other day, I was driving with my coworker, and they pulled us over and they said, "Ma'am, your fitness is up." Well, they introduced themselves properly, because they did say, "I am officer this, and we are conducting, safety checks and so on, and your fitness is expired, and we are going to be providing you with a ticket." And then go back and print the ticket and come back. Right? So yes, it is. All right, so when we go to the home now, as we say, you need to have a warrant. There are very few exceptions with your home. The exception is there's somebody that they're chasing, it's a fleeing felon, and they have followed the felon, and the felon go through your yard. They can search the home in that time. Why do you think that is? If the police are pursuing someone and the person comes through your yard, the police can now search your yard without a warrant. Why do you think that is? They could be in there, they could have left evidence in there, right? So they have a non-arbitrary reason to be searching your home without a warrant. Of course, if the police observe an offense on view, they can search your home without a warrant. So me I do my patrol, and me hear woman screaming at the house and a ball out for help, me can enter the house now and see to ensure that she's safe, right? But otherwise, I should have a warrant, and my warrant should be properly constructed. So the person on the warrant are you, and the house on the warrant is yours. There's no mismatch in terms of the premises and the person that are involved, right? All right, so we're going to talk about arrest and detention and bail. Are we aware of our 2023 Bail Act? Everybody's familiar with it? 2023. Yes. So you know all about the pre-charge bail and all right. So In 2023, we changed our Bail Act fairly significantly, and it has some implications for what arrest and detention is now, right? So before, you could have been detained, and that detention was on a limited basis. You're detained for 24 hours, they would come to a JP for an extension if necessary, detained for a further 48 hours before you lay charges. Now, if you are a defendant that has not, and I hate using that word, but that's what the act says, so I have to use that word. So if you are a defendant that has not yet been charged, then you are a pre-charge defendant. And there are lots of things that can happen with you that are not just within the 24-hour to 72-hour thing that we had before, right? So I'm going to talk about it. But before I talk about it, just to remind us about our regular bail, and then we'll talk about the pre-charge, right? So definitions in the legislation, and I'm sure you as lay magistrates would all have read it or will be reading it after this. But in the legislation, you will see throughout a word deciding official. A deciding official could be any of these people that you see here. The court, the judge, the justice of the peace, the constable, whoever it is that the section requires. Each section would specify which deciding official they're talking about, but that is in the subsection. So say, for example, let's say section 5 says, a deciding official can grant pre-charge bail for the offenses in Part 1, Schedule 1 of the Act. Then it will say at subsection 5.3, a deciding official in this section is a constable above the rank of superintendent, a judge, a lay magistrate, or JP, whatever. So you would need to look at the sections with scrutiny to know exactly which ones apply to you as a JP versus which ones would apply to you as a lay magistrate, which have remit over the lay magistrate's jurisdiction, which one would apply to you, which one would apply to police, which one would apply only to the court, right? Now, our ordinary bail remains relatively the same. So you have been charged with an offense, you are to be considered for bail within 48 hours. Bail is a right that you have as a Jamaican citizen, so you must be considered for bail. Why would bail be a right? Why do we think it's a right and not a privilege? Right. So you have the right to freedom of the person. You have the right to liberty. You have the right to freedom of movement. And one other right we have to do with you being able to do what you want with yourself, right? If you have charged me with an offense, you are saying that there might be circumstances for which you can restrict my right to liberty and freedom of the person and freedom of movement. That there might be those circumstances, right? So if I am going to, from now that I am charging you, restrict your right even further by detaining you, then there would need to be some very good reasons, like I will not show up to court, or I will harm the person who is involved in the offense, or I will tamper with witnesses, I will tamper with evidence, I am a flight risk. Outside of those things, you're going to give me bail, right? Because I have a right to move freely, and you have not yet proven that that right should be restricted. You only suspect that it should be restricted, right? That is why you have a right to be considered for bail. It is not a privilege. So when we hear people say, oh, but this man get charged with a whole heap of something and him get bail for all of them, that's because they did not convict him for anything. You charging somebody means nothing. Nothing. Because you can charge people and you go before the court and the prosecution lays whole case and then the defense make a no case submission. You know what that means? That even the evidence that you brought to court was not enough to go any further for me to even answer to the allegations that you made. It was not enough. And that would be somebody that already reached into the courtroom, right? So we have this right to bail and it must be enforced. So when you are considering whether or not to deny bail, your major consideration is whether or not the person will show up for court. right? But you can also look at things like the nature and seriousness of the offense, the need to prevent crime, the defendant's background, the strength of the evidence that is against that defendant. Because suppose it is a matter where the evidence is a video, and the offense is clearly caught on the video, and the defendant facing at the video, and the victim in the video. That is some very, very strong evidence against this defendant, right? So maybe you would not want to be granting this defendant bail on the risk that they will not show up to court, considering how strong the evidence against them is, right? You also have witness and victim proximity. So say, for example, this defendant live in the same community as the victim, and you are concerned about tampering with the victim or the safety of the victim or witnesses, and them don't have nowhere else to go, right? Then that would be a consideration for denial. Keep in mind, if they have somewhere else to go, then the order would be made for them to go elsewhere, right? Because we're going to try to preserve that freedom as far as we can. Public confidence and security. These things now, at the bottom, were additions other than this one, were additions to the 2023 bail legislation. So the use and possession of firearm, the mental health profile of the person, and in the case where there was a murder, whether or not it happened in a state of emergency or a zone of special operations. Right? So those are your considerations when you're considering if you're going to deny the bail. Now keep in mind, even though you're making these considerations, bail have conditions. And if any of the considerations that you have here can be managed with the conditions, you are to grant bail with conditions. Because also, it's not like we have whole heap of space for a whole pre-trial defendants, right? When we go to the pre-charge bail now, there are a couple of things to consider. So one, a defendant is detained. They have not been charged. The police have 48 hours to decide what will happen with that defendant. In that 48 hours, they can place them on pre-charge bail. They can charge them. They can release them unconditionally. They can keep them detained to bring them before the court so that the court can decide if they will be placed on pre-charge bail. So, the pre-charge bail should be there to allow for the police to complete their investigation. And what it would do is release this person on conditions without charge, right? So, the person is detained. Within 48 hours, the police, it is an offense that is in Part 1, Schedule 1 of the Bail Act. The police can grant pre-charge bail for those offenses. It's one of those offenses, and the police said they are granting pre-charge bail. The pre-charge bail would be granted within the 48 hours, right? So within 48 hours, it should be released on condition. The conditions are limited, so you can provide surety or bond. You can have reporting condition to stay away from witnesses, to inform the officer that you're going to leave the jurisdiction. They can't stop you from leaving the jurisdiction, which is a normal bail condition, right? But you can inform them that you're going to leave the jurisdiction. If the pre-charge bail is granted by the police, you can be on these pre-charge bail conditions for up to 6 months without the interference of the court. Before the expiry of the 6 months, they are to apply for extension if that is necessary. If they apply for extension, the extension can go up to a further 6 months. That is 1 year, right? Okay. If you are detained and it is an offense for which the police cannot grant pre-charge bail, you can be detained for up to 4 days in those circumstances. Because in the first 48, they would be deciding what to do. And then they would have another 48 to take you before the court. When you are before the court can decide if they will grant the pre-charge bail, if they will release you unconditionally, if they will detain you. If the court detains you, then you are detained until your next court date, whenever that is. If the court gives you the pre-charge bail, they would be using the same timelines that are in the legislation. If the court releases you unconditionally, that is it, right? Another situation that you can be in is if you have been detained for the purpose of conducting an ID parade. So you will be in the ID parade, and they have detained you for that. they have 5 days to conduct the ID parade. So that is a 5-day detention for them to conduct the ID parade. If after in the 5 days them to complete the ID parade, they have 48 hours after the 5 days to apply for an extension. When they apply for the extension, the court can grant a further 48 hours on that time. So that defendant, if they don't complete it within the further 48 hours, the defendant is to be released unconditionally. So that would be 5 days, 2 days, 2 days. That's 9 days that you can be detained just for an ID parade to be conducted. Right? Keep in mind, in the first instance, they can be detained for up to 4 days for them to consider the pre-charge bail. Right? Now, we have whole heap of problems with this section as a human rights organization. Problems that we have made clear to the parliament. We made submissions on this piece of legislation multiple times. We would have also made public statements on the issue. Pre-charge bail is a mechanism that only exists in one other jurisdiction in the world, and that is the UK. They have had it since the 1970s. They have rolled it back every year since then. I think about 1976 or 77 they've had it, and they have rolled it back every year since then because of how many breaches of rights have taken place due to the pre-charge bail. When you are placing a person on pre-charge bail, you have even less evidence than you would have had for a person that you are considering for ordinary bail. Yet still, you are putting extensive restrictions on a person that there is no prima facie case against, right? In the UK, the kind of problems that they saw was with the length of the restrictions. Similar times to what we have here, and so they have rolled it back all the way to where they place a person on pre-charge bail. They have a maximum time of 2 weeks in which the person can be on pre-charge bail. They used to have all of these extension, but they were severely abused. But also, some of them in the basic mechanism would be unconstitutional. And that was a consideration that we had when we looked at these provisions in tandem with other common law matters that we have seen that have to do with detention and restriction on your rights. But we're going to talk about that. I just want to say this before. As we said, the conditions with the pre-charge bail are limited, so it is only surety and bond, staying away from witnesses, reporting to the police station, informing that you may leave the jurisdiction. If you're on pre-charge bail, those are the only conditions that you can have. If you are on ordinary bail, you can have those conditions, but all the other ones too. So taking away your travel documents, telling you to stay within the jurisdiction, keeping you on curfew, all sorts of things that can happen when you are on ordinary bail. Those still exist. They're just not available for a pre-charge defendant. And of course, all bail decisions can be reviewed, and it can be reviewed from either side. So another thing that we often hear is, similarly to, this person get charged multiple times and them get bail all of the time. When it is that a person is before the court, their lawyer comes and they make a bail application. The prosecution, just like the defense, can respond to that application with all the reasons why I should not get bail, right? I have been charged this amount of time, and they were for this kind of serious offenses, and it's a similar kind of victim. Whatever it is, the information that the state have or the police have, they can share that with the court for the court to consider when they are considering my bail. If the prosecution does not offer any evidence when I make my bail application, all the court have is that I am a good upstanding citizen that will show up to court, and so they will grant the bail, right? So if it is that they have an issue with the bail being granted, they can always review that, right? And the court can change its decision and revoke the bail that was granted. It can add conditions, it can remove conditions, right? So it has the power to do what is necessary to ensure that the defendant show up to court, right? All right. Now, one of the reasons we have this concern with the pre-charge is because of the things that we have seen coming out of the state of emergency. Right, so I did say we're going to talk about it earlier. We have under our section 26 of the Constitution the reasons for which our state can call a state of emergency. And those things have to do with disasters and destructions and pandemics. So for example, when we had the hurricane in December, we called an accurate state of emergency, right? Because we would have had destruction in our western area, no light, there's no access to essential services, and so we would have been in a state of emergency. However, the ordinary crime rate, and it's not just me saying this is also the opinion of the Supreme Court, is not a state of emergency. That is the crime rate we have had. So putting in a state of emergency would be an incorrect use of that mechanism under the Constitution. The first matter to challenge that was Everton Douglas and his co-defendants. And they did this on a habeas corpus application. This is a matter that JFJ brought. Right? And in that matter, we saw where these gentlemen were held for this length of time. The time next to them is the time of their detention. Keep in mind, none of these men were ever charged with anything. So that means there was never enough evidence to support a prima facie case against them. Right? Okay. I don't remember which one of them, but one of these men, his child was born in the time that he was detained and he was not there to see the birth of his child. They applied for the habeas corpus. The court looked into the reasons for their detention. Looking into the reasons, the court looked at the state of emergency and found that it was an illegal state of emergency because there was no reason under the Constitution to have called it. Similarly, well, not similarly, but additionally, the regulations that supported that state of emergency also had several sections in there that were unconstitutional, which the court ruled on as well. Having found that the state of emergency itself was unconstitutional, that the regulations under which the men were detained was unconstitutional, the detention itself would have been impermissible. And so the men were released. The state appealed, they lost. So the court found that its judgment was sound. Following this case, we saw opportunistic defendants who would have been caught up in a similar state of emergency, if not the same one, sue, because we just said the state of emergency was not legitimate. And in suing, this man, Shane Clark, who was detained for 7 months, meaning, and when I say detained, all of these people were never charged, right? So Mr. Clark, detained for 7 months, received his $18 million settlement for that detention. Mr. Mitchell, who was detained for 20 days, received his $5 million settlement. And we've seen many other lawsuits filed within that time, but they just have not finished hearing them as yet in terms of coming down with the judgments. Mr. Douglas and his co-defendants would be among that number because they were waiting on the appeal to be concluded before they moved on with the civil side of their matter, which they're on now. So you can imagine how much money us taxpayers will be paying to these gentlemen for that illegal detention. Now, looking at the period of time for which they would have been detained / restricted, and then looking again at the provisions that are in our pre-charge bail legislation, where a judge can detain a person who has not been charged for an unnamed and extended period of time, you can see why we might have some concerns about how that piece of legislation will work with what our Constitution says. Furthermore, we saw the matter with Dayton Campbell, where he brought an inquiry to the Constitutional Court about all of the previous states of emergency that would have been called. And the court found them all to be unconstitutional. So you can imagine that if you were detained but not charged in any of them, you would be looking a lawyer right now, right? Because you would have a cause of action to sue for that false imprisonment, malicious prosecution from the state, right? All right, so that is it on the bail. So do we have any questions about it before we move on to treatment in custody? Yes.
Based upon the state of emergency, where it says that more than 4,000 persons were detained,
Yes.
could JSJ or some other body then do
A class action.
class action? Yes.
Yes, that is a possibility.